My name is Steve Brody, and with me are two of my colleagues, Mike Margulies and Robin West. Robin is headquartered in our Atlanta office. I'm headquartered in Miami, and Mike is in New York. I co-chair our insurance practice groups, and I guess I've had the pleasure, along with Robin and Mike, of working with Sampo for years and years. And what's great is I see many friends in the room that I worked with in their prior iterations. And I think I'm so excited to see what Sampo is doing in your recent merger and the growth. And you guys are really on a tear. I want to say that we really value the partnership with Sampo and thank all of you who are in the room in person and all of you that have joined us by internet and by Zoom. Let me start off by saying this program is entitled Maintaining the Claim File Privilege and Discoverability Considerations. And I usually start these presentations with a little background of what we're trying to accomplish. Some of you may have heard me say this before, but it's really how I practice every day. And that is, I want to win. And I think about winning and what WIN stands for. WIN stands for what is important now. Where did I get that slogan from? I don't want to say I took it. I happened to really get that from Lou Holtz when he was the coach of Notre Dame, came to speak at I think it was a large industry event. And he said that when kids come on campus as freshmen for football, he tells them, well, you're here to win. And what is winning? He goes through the whole thing of what is important now. So our view is that hopefully at the end of this program, you'll take away what is important now when you are putting together, maintaining a claims file. And the most important thing is that this day and age, the demands placed on all of us by emails, by text messages, by calls, the volume of claims you're all handling is overwhelming. Agreed, understood. And at the same time, it's important to understand that when you respond to either a broker, an insured, counsel, anyone, you are creating evidence. And why 90+% of claims never get into litigation, it's always those few exceptions that create problems. And we go back and look at the claims file, we go back and look at the underwriting file, we go back and looking at internal communications and other communications, and depending upon the state in which the litigation is pending, whether it's state court or federal court, or what state, whether or not the claims file and underwriting files will have to be produced. So what is a win? A win is hopefully you'll think and reflect upon every time you take the note when adjusting a claim, when you're talking to someone internally, when you're talking to your supervisor, you may be on a conversation with an underwriter. What do you put in your file to maintain your communications? Because that in and of itself is critical evidence. So I'm going to turn it over to Mike and Robin. I'm going to kind of be, even though I consider myself the gray-haired one, I have gray hair. I'm going to be jumping in and out depending upon what we're talking about, giving real-life examples. Because I think the best way to learn is actually looking at things that have taken place where you can say, oh my God, I did it. Why would someone do that? And again, these are real-life examples we have. We're going to protect the innocent. We're not going to tell you which insurance company or who did it, but these are real examples we have seen ourselves or in other litigations. That's things that I think create issues. So, Michael.
Hi, everyone. So I'm going to sit. I apologize. I'm going to sit because otherwise the people on the screen are going to be looking at my belt buckle, and that's probably not the best look. Steve, the way Steve started this, discussing a win.
Well, I think our winning record is like in the 90%. So
yes, we always want to win. So we are coverage lawyers, and as coverage lawyers, we have a view of claim files and claim file maintenance that might be somewhat come from a somewhat different perspective than all of you has as claims persons. And we are generally presented with claim files in the context of litigation and discovery. And we want to make sure that the claim files are helpful in that context, or at least not problematic in that context, to our position that we take in support of you all. So we thought it would be helpful to share our perspective in order to incorporate that perspective into how you maintain your claim files. So claim files should contain clear and concise communications. It's important that you thoroughly document your communications and the information provided to you. But that does not mean that everything should go into your claim files. Remember, the claim file, I think as Steve mentioned before, it may become a critical piece of discovery and litigation. So you may have to very well defend what was included in the claim file, but you also may have to defend what was not included in the claim file. Emails and Slack messages, kind of informal communications, that's what a lot of us operate on every day, all day. But these informal communications can oftentimes be dangerous. They're often our rough thoughts or assessments, and we're pretty quick to take those and just incorporate those into kind of what we do into the claim files. But best practice is to actually think a little bit more thoroughly and comprehensively about what's incorporated in there. And from our view, best practice is always, if you're communicating with someone, the best thing to do, what we still all have at our desks, is your phone, is to pick up your phone. If you're talking to a colleague or if you're talking to us as counsel, and we'll get to this later, communications with us as counsel sometimes may be subject to a privilege and protected and not disclosed, but sometimes they may not. So whenever you have a question for counsel or a colleague, pick up a phone, talk it through, discuss the issue, land on your position, and then you can document the conversation how you want it to. I can't tell you how many times I get an email from clients that essentially say, hey, we're looking at this exclusion. What are your thoughts on it? And I can either respond with my thoughts, and that email can potentially come up in discovery or in a litigation later on. Or what I do is say, do you have some time to chat? Which also may later be the subject of a deposition. Hey, what'd you talk about with counsel at this point if it wasn't privileged? But it's a lot easier to have a conversation. Sorry, I should say it's a lot easier just to write the emails, but it's better practice and takes a bit more time, but it's more comprehensive and thought through to have the conversation, and then you can figure out the position together with your colleague or with counsel, and then document and then incorporate it into the claim file. So in the context of discovery and litigation, we have seen examples of things that are great, claim files that are great, thoughtful, comprehensive claim files that help us win cases. But we've also seen claim files that are rushed, sloppy, have too much in them, have not enough in them. Example, communications or information documented that require, or handwritten notes that require explanation to judges and juries and adverse attorneys. So we want to stay away from those. So we want to talk through some bad examples of what we don't want to do.
Let me just say, it's hard for you to imagine at the time, but understand you are creating evidence. And evidence created can either help or hurt. So many times we're all quick to respond. I am also to blame for it at times where I don't prove something, I quickly want to respond, and I'm sure that I say things that in hindsight I wish I said differently. So we're all in this world. I know that our kids are only texters. No one talks to anyone. And sometimes in hindsight, you reflect and you're not sure exactly what the message is when you're texting, and it's subject to interpretation. So just remember, everything you're doing, you're creating evidence.
So here's an example of something that we don't love. Don't write comments in a claim file like pure BS with an exclamation mark at the end. A better approach might be, here are some issues to take a closer look at. Or if you feel that you have to write pure BS in your note in the claim file, just don't include the exclamation mark. Always think about always think about how you're going to have to later explain whatever it is that you write or whatever you incorporate into your claim file. Because if things go into coverage litigation, like Steve's alluding to, you're going to have to explain it later. And it's better to have that explanation in whatever you're documenting in the claim file, as opposed to sitting down with me for 6 hours to figure out how we're going to respond to the questions that come up in your deposition. Not a fun process. And we know that each of you have hundreds of claims that you're dealing with, but it's always better to take the time to deal with these things on the front end as opposed to the back end. The back end always takes more time and is more problematic.
And by the way, this is a case in which someone at a Home Depot, some felon, him paraplegic, was wheelchair bound, and part of the claim was we need to make sure the house he can survive and properly prosper at home in the house. And when the questions was hard floors required, this would be in a wheelchair. And this is a comment by the adjuster. So you see the context of a casualty claim and a feeling someone's trying to upgrade the house to better floors and other things. So you see, something that will maybe resonate when you think of the claim.
And building on that, here's some more examples that we don't love, right? Some more handwritten notes, 11K, too much, exclamation mark, ouch, 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 and just so many exclamation marks. I don't like exclamation marks. Again, the better approach would be, instead of dropping in the shorthand, a handwritten note into the claim file, just draft a short explanatory note that you have thought through, that you can incorporate in and think about what questions might this bring up at the end of the day? Where is this going to go? My general thought on handwritten notes is that I don't love them. They're a pain. In the context of litigation, handwritten notes are a claim. We understand that people go to in-person meetings and take notes. But at the end of the day, when we have to produce handwritten notes in discovery, not only can we not read your handwriting, and I'm sure you can't read my handwriting, at the end of the day, every maybe third word we can read. But at the end of the day, it's just they're kind of reactionary items that you're writing down, a synopsis of what you're hearing. But if you take the time to go back and take whatever handwritten note is and put that into an electronic file and just write a synopsis, a clear, concise statement of where you were, what you heard, what next steps are, it's much easier to deal with later on at the end of the day, at the end of the day, or in the future when, should discovery or litigation arise. So everybody can do better. Again, we know it takes a little bit of time and effort, but everyone can do better. What we don't like it is an example like, it looks like this is going to be a difficult case. Claimant's counsel is well known for abusive discovery techniques and inflated demands. I will advise our attorney to play hardball. This is just, it seems innocent enough, but it's not helpful. It's not constructive, right? It's critical. It's not constructive. A better way to put it might be, claimant's counsel is known to be uncooperative in this litigation process. I'll advise our attorney to exhaust all efforts to be conciliatory, so long as it does not compromise our insured's rights. So taking the reasonable approach always plays better before a judge and a jury and at a deposition. We don't want to be confrontational. We want to be as reasonable as possible. Some other examples, what we don't want to include are, based on reports from counsel, I have established a reserve of policy limits, period. We don't want to box ourselves into a position, especially at the early stages where not all the information is known. And you do this all the time. In the reservation of rights letters that you issue, they all start out with, this is based upon the information we have available to us right now, right? And every letter is concluded with, should you have additional information, please provide it to us. And if we come across additional information, we'll revisit our position, and rights are reserved accordingly. So a better way to put it would be, based on reports from counsel, I've established an initial reserve of policy limits subject to revision downward as discovery proceeds. It's the same context as reserving your rights should information arise later, because more information always comes out. You always get more information later, and you want to take a step backwards and adjust what you did previously, but it's already out there.
And this comes from a first-party property case where you are adjusting the claim during the claims process. So I'm trying to get the context of it. Obviously, our view is reserve information should never be produced in litigation. But it's also important when there's things like this, because there's always going to be fights with what can and can't be produced. Unfortunately, some judges seem to be expanding liberal discovery. And so we have to, a win is to avoid having these things, even though we think it's protected. In the majority view it is, but we need to make sure we're, and I also would caution, the important thing is to make sure you don't appear that you're not adjusting the claim. There still are be able to maintain attorney-client privilege. Between counsel, if you have counsel who's assisting you in the claims evaluation, I think it's always important, because if the lawyer is deemed to be part of the adjusting of the team, then there's less likelihood that it could be protected, and maybe even the lawyer's file would be subject to reduction. So even if you're conferring with counsel, our view is you are the adjuster, you are making the coverage determinations. Counsel may be informing you, and it's important, generally in our view, we want you guys to be authoring the coverage letters. If there's pushback, if there was counsel for the insured who's engaged, that's different. If we start citing cases, we've had cases where carriers say, no, we want our adjusters to sign every letter. And we have a letter that we were asked to prepare that cites all these cases. Fast forward, you're in litigation, and did you read these cases before you cited them? No, I never even saw the cases. So just everything you do in creating the record is important to think through the issues.
Yeah, and we'll get to privilege issues in a little bit, because they're obviously very important in the context of claim filing, claim file maintenance. So why is all this important? Keeping good records is an opportunity to create good evidence. This is what Steve keeps saying and harping on, and it's the truth. This is what we work with as lawyers at the end of the day. So say things the way you want the jury to hear them. Jokes, sarcasm, things of that nature, even though they might be harmless and might not even be problematic to the case, there are always things that have to be explained away. My favorite thing is when I find a sarcastic comment or a joke that a witness wrote, and I get to depose them on. I just get to needle them for hours and hours and hours about these kind of offhand comments. And back and forth discussions regarding coverage, they may be used to suggest that a carrier was simply looking to avoid coverage, which will be a chief exhibit in a bad faith claim. So if there is a later coverage dispute, as we mentioned, everything you write in the claim file, it will become evidence and may very well become the subject of a deposition. So the best practice, again, is to think about the future, the possibility that there may be discovery and there may be coverage litigation that you might be involved in. It's not fun for you. I can assure you it's not fun for us as well, to explain away casual language, jokes, things that you don't want in your claim file, and it's not fun to explain them away later. So again, best practice. Pick up the phone, start with a phone call, think about what you want to say, think about how things will play out in discovery and depositions in court, and then write your notes up clearly and concisely. So jumping out to privilege considerations.
Yeah, I won't show you if I could real quick, Michael. Another area that comes up in this regard is early on. So you get a claim in, and you look at the policy, and you say, well, what is it? What did the underwriter mean here? Red flag, do not put in your file policies ambiguous. Well, I don't understand what the policy means. I need to call the underwriter. Is that okay? Because we all know the general law is that if there's an ambiguity, it's construed against the carrier in favor of the insured for coverage. And even though you may have made an innocent comment that I don't understand it, it creates the specter that there is an ambiguity. So if you're not sure, as Michael said, it's best to have that conversation than to write to an underwriter, I don't know what you meant here, or this endorsement. I've never seen something like this before. I can't understand it. Those are bad things to have in your file.
So a quick recap of privilege, which I'm sure you're familiar with, but everyone can use a recap on privilege. And oftentimes there aren't clear answers. So there are four elements of attorney-client privilege that we look at. So communications, it must be a communication. So an email, a letter, a memo, a phone call. either between counsel and client or relaying information from counsel. So if you receive information from counsel and then you share it with one of your colleagues, that might also be subject to the privilege. The privilege may also travel along with that communication, so long as the attorney is conveying legal advice to you and that's what you're passing along. The communication must be for the purpose of obtaining legal advice, and it only applies to legal advice. And that's distinct from business advice or other discussions. And as we'll talk about in a minute, there's not always a clear line of what delineates legal advice and business advice and other discussions that you might have. The communication must be made in confidence. It's not intended for others to hear or read or learn about. And the communication must be kept secret, and such that the communications are not shared with others, not shared with third parties. So what types of discussions or what types of communications are not protected? Disclosures to adverse parties in litigation. So plaintiffs, the insured or plaintiffs in a coverage litigation, communications with them will not be protected. Disclosures to regulators. For example, voluntary disclosures to regulators that are not compelled by subpoena, oftentimes not privileged. I have a coverage litigation for Sampo right now that's pending in Delaware, and the court recently ruled that the insured it involves communications and reports between the insured and state banking regulators, and the court ruled that the communications between the insured, despite that the insured was trying to argue that they were privileged, the court ruled that the communications between the insured and the state banking regulators are not subject to the attorney-client privilege, even if the attorneys for the insured were on the communication and made the communications. Though there are various statutory privileges that regulators, that these banking authorities, state banking regulators can assert on their own, these statutory privileges. And otherwise, generally disclosures to other governmental authorities, also generally not privileged. And there's other rules that can also prevent disclosure, though, not just the attorney-client privilege. There's the attorney work product doctrine. And this states that once litigation is anticipated, work and communications in furtherance of that litigation is protected, even if it's not involving counsel. So for example, if you're doing work to prepare something to assist counsel in the furtherance of litigation, that's, litigation's anticipated and you're doing something to assist in the furtherance of that litigation, your work in preparing that will be protected in that it's supporting what we are doing as attorneys on the matter. There's the insured privilege. So when there is a duty to defend, communications between the insured and the insurer are often protected, even without the presence of a lawyer. But you have to be careful with this privilege, because this privilege may not apply where there's no duty to defend or where there is a reservation of rights. So not a clean privilege that always applies. It depends on the situation and the circumstances. And then there's the common interest privilege. Communications between parties that are similarly situated. Those parties have a common interest in a defense. Having a common interest in a defense, those communications are privileged. The best practice is for attorneys to be involved in those communications to ensure that the privilege remains and is not broken and it's maintained. But even if the attorneys are not involved, the common interest privilege may still survive even without lawyers on it, depending on the situation. And that privilege, so even though those are communications, not just attorney to attorney with client, they're communications with third parties, the privilege may still remain because there is a common interest. So one example that we find all the time is when we're in coverage litigation and our side of the V has various carriers on a tower, we often enter into a common interest and joint defense agreement because the insurers generally have a common interest and can share information amongst each other, a common interest on our shared side of the V against the insured.
Let me just quickly, a few notes here. How about anticipation litigation? That's always a tricky thing. When do you anticipate litigation? Because that shows that you may see a conflict. What's important also comes along with that, the duty to preserve the file. and emails and things of that nature, because you can't go ahead and anticipate litigation, but throw away notes and throw away other things that are taking place. As far as the common interest privilege, it's a great question. Many times we're dealing with that issue even before litigation. We're involved in assisting you on coverage issues, and there's a tower, and the carriers want to know what is Sampo's primary. They want to know our coverage position, and especially we dealt with some very tricky issues on allocation. And if we want to allocate under the policy, what is everyone to agree with? What's a proper allocation? Obviously, excess wants to see everything on the primary, with the primary coverage position, especially follow form, they want to be involved. These are all things that you need to think about when communicating with, within Sampo, with excess carriers and with counsel and the insured.
Yeah, so with privilege, like Steve was saying, there's oftentimes a lot of blurred lines. In anticipation of litigation, that's a blurry line. Another blur, and we'll address that in a minute, but another blurry line is, when is a lawyer a lawyer? When is a lawyer acting as a lawyer? Because as I mentioned before, attorney-client privilege applies only when a lawyer is acting as a lawyer. And the lawyer must be wearing their lawyer hat and not their business hat for the privilege to exist. And courts often turn to the predominant purpose test to determine if a lawyer is acting as a lawyer or in some other capacity, as a business person. In New York and a number of other states, they apply the predominant purpose test. And New York courts have said that a lawyer acts as a lawyer where the predominant purpose of the communication is to render or solicit legal advice. And so long as the communication is primarily or predominantly of a legal character, the privilege is not lost merely because it also refers to certain non-legal matters. So if the predominant purpose of the communication is legal, then the entirety of the communication will be considered privileged. California has a little bit of a slightly different approach. California, instead of focusing on the communication, California focuses on the nature of the relationship between counsel and client. So in California, the court has said that it's not the dominant purpose of a particular communication that dictates whether the attorney-client privilege is applicable. Rather, the issue is, what was the dominant purpose of the relationship? So it's taking a broader, a more holistic view of the relationship as opposed to the specific communication. And under the predominant purpose test, what counts as legal advice? And as I mentioned before, it's a blurry line and it's hard to tell because lawyers often act in different capacities. And the blurred line that we see typically is between lawyers providing legal advice as opposed to business advice. And the context of the work that we do with you all, the business advice would be seen as assisting with the adjusting or handling of a claim, as compared to providing legal advice, where we really see more so in the coverage counseling context, or kind of when we're moving towards, and to use another phrase, in anticipation of litigation. So the answer is not always clear, and courts treat the matter differently. In Washington, advice about coverage obligations might be legal advice. They say that legal advice addresses whether or not coverage exists under the law. But that's not always the case. In New York, for example, New York courts say reports which aid in the process of deciding whether to pay or reject claims are made in the regular course of business. So again, it's where do we draw that line between business decisions, adjusting a claim, and legal advice, providing coverage counsel advice. So we've had recent coverage litigation where the court has decided that it's going to draw the line for us, and courts have said that there's a clearly delineated date where before that date, communications are going to be considered business communications and not subject to a privilege. And after that specific date, they're going to be considered legal communications and they are subject to a privilege. And the experience that we've had recently in a number of cases here in New York in the commercial division and in other states as well, the court really starts to draw the line at when a declination is issued or when the carrier makes a determination that the claim will be declined, that the claim will be denied. So while under a reservation of rights, court has considered communications to be not privileged, not subject to a privilege. And the privilege won't arise until the declination is decided or the declination is issued. And at that point going forward, that's when the privilege would kick in. So because you all think, as I'm sure that most people do, that the default is going to be that when I'm talking to my lawyer, it's a privileged communication. It's going to be protected. I don't have to worry about what's written or said because it's not going to be produced in discovery. But like I mentioned before, it's not always the case. There might be a point at which communications become privileged, but everything before that might not be subject to a privilege. So our view of the best practice is when you have questions for your lawyer, when you're talking to your lawyer, pick up the phone, have a conversation about what questions you have, get your lawyer's feedback, come to the position that you're going to be taking with your lawyer, and then you can start sending emails out or start documenting your file accordingly.
Let me add there. What is a win with some of these communications if you do and you're really concerned about those red flags that this may end up litigation? Put it in the reference, attorney-client communication. I always take the position that when we're assisting you in the claims and we say we want to talk to the underwriter, we say, let us be on those emails. Let us be part of those conversations so that we can take the position that these are attorney-client privilege communications. I'd rather try to have the protection if we need it than not. So you want to make sure if there's questions you have that you want to internally communicate, it's best to have a lawyer on those communications. It's best when you first have a discussion with the underwriter about policy wording, meanings, and whether, there's coverage or the exclusions apply. Those type of communications, we should do everything we can when and if you're documenting it, to do it in such a way for it to be protected.
Okay, so we're going to start getting into the duty to defend world and talking about protecting privileged communications with insureds and your insured's defense counsel. So as Michael alluded to earlier, there is a magical insured versus insurer privilege, but it is not widely recognized. So certain states, but not all, recognize this. For instance, in Georgia, where I primarily practice, there is no insured privileged. It applies only where the insurer has a duty to defend. And the good thing about this, if it is applicable, is that the statement doesn't have to be made by or to a lawyer. So it can exist outside of that specific context where you would normally think that it would be protected. But the privilege is waived if the information is shared with a third party outside of the insurer, the insured, and the counsel.
That be broker too, Robin?
In certain instances, just because, which we'll get into next, this privilege is sort of seen as being born out of the attorney-client privilege. So I think a broker sharing that information with a broker would probably destroy it. So like I said, certain states, but not all, recognize this privilege. And it, let's see. In Montana, for example, the privilege covers any communication between the insured and insurers, which relates to the duty to defend, and the duty to report and the duty to indemnify. So pretty broad. The privilege applies where the insured communicates with the insurer for the express purpose of seeking legal advice with respect to a concrete claim. So it's not sort of like a broad question and answer session. Like, it has to be related to a concrete claim. So in some jurisdictions, like I said, it's not recognized. And Georgia is one of those. So I guess with this one, it's best not to think of it in terms of like a general law. Like sometimes there are general laws, like Steve mentioned earlier, about things being construed against the insurer. This, to me, seems pretty rare. So I wouldn't just think, oh, we have an insured privileged, and go about documenting the claim file that way. So there are some limits to it as well. The statement has to relate to the insured's need for legal assistance. And the dominant purpose of the privilege statement must be transmitting it to an attorney for the protection of the interests of the insured. So in this case, like we talked about a bit earlier, it didn't have to be communicated to or by an attorney, but in some states that do recognize the privilege, it does. So if they're not seeking legal advice, it's not going to be covered under this privilege. The hard thing about this, as far as we were talking about blurred lines, the case law obviously does not flesh out what kinds of statements or communications fall within this, because in most times we're arguing about the privilege, right? So it's hard to tell what kind of statements would be protected by this. So just fall back to the fact that it has to relate to the need for legal assistance. Okay. There's also some privilege concerns when we get into this tripartite relationship. Courts have struggled with trying to conceptualize this, and this is the relationship between an insurer, the insured, and counsel retained by the insurer to defend the insured. So as we're about to see, there are tons of ways that courts have tried to tackle this, and it is very, very jurisdictional specific. In some jurisdictions, the insurer is thought of as a joint client of the insured's defense counsel. I would say that's probably a minority of the jurisdictions. In some jurisdictions, the insurer can be seen as a client of the attorney if the insured gives informed consent. Also, I believe a very rare sort of way to look at the tripartite relationship. Another issue that could come up with this tripartite relationship that courts have been struggling to figure out, as Michael alluded to earlier, if there's a reservation of rights letter, things can be tricky. Because some courts think that at that moment there becomes some sort of adversarial relationship, and that at that point the lawyer cannot effectively serve both the insured and the insurer. So when conceptualizing this relationship, some courts really look at that relationship and really look at the communications issued by the insurer to determine whether they can rely on this sort of privilege. And then in an even smaller number of jurisdictions, they look at it as the insurer being the third party beneficiary of a contract between defense counsel and the insured. Again, everything is sort of the court's way of trying to understand or work through the practical concerns of an insurer's relationship with its insured and defense counsel.
By the way, this really only comes in about coverage litigation, which is important to note because generally our view is you do have a tripartite relationship, even as long as you haven't denied coverage. If you've denied coverage, then our view is that the insured is relieved of its obligations to cooperate under the policy, relieved of its obligation to get consent from the insured and settled. But if you haven't denied coverage, if you are either advancing defense costs, paying under duty to defend, or reimbursing, you have that tripartite relationship because you really want defense counsel, by the way, whose duty is to the insured. Even a duty to defend, even if you are appointing defense counsel, the professional rules of responsibility lawyers say, even though Sampo is paying my bills, my client is the insured. That's where my duty of loyalty is. And part of that duty is that lawyer cannot do things to affect coverage to his or her client. So you cannot ask, even though you appoint defense counsel, to help you find evidence as to why it may not be coverage. Other than that, you have to understand the tripartite relationship, and you want to honor the tripartite relationship, because if you are paying defense costs and you are adjusting the claim, you need to have a good assessment from defense counsel as to both, expected defense costs and liability and evaluation of claim.
Right. And I will say just another fun way a court has tried to look at this. If you look at the last bullet point, it's been described as a magic circle within which confidential information can be shared. So that just goes to show you how complex this issue can be if it comes down to litigation and the insured and the insurer end up on adversarial sides of the ball. So, and we can move on to whether a third party can get access to an insured's communication with insured's counsel. In most cases, the answer is no. So they are going to either be protected by this attorney-client privilege or this, what we just talked about, the ever evasive insured-insurer privilege. And I just do want to point out that there's a lot of variation in this, especially in the lens of whether it's an extension of the attorney-client privilege, because that issue is governed by state law. Federal law will govern work product, but as far as attorney-client privilege goes, it's a state law issue, which is why all these states have come out different ways on how to deal with this. Okay. Skip this. This is pretty much what I was just talking about. So, and if we're going to let's get back into what the reservation of rights may do in this instance. So when defending under a reservation of rights, an insurer may be seen as not having an attorney-client relationship with the insured's counsel. And that's, again, because some courts will consider that adversarial. And to Steve's point, defense counsel's priorities should be aligned with the insured. But what we'll get into later is that there is also something called the common interest privilege that may step in where this insured-insurer privilege causes a gap. So like I said, some courts say that a reservation of rights can destroy this privilege. Some courts understand the practical nature of having that open communication that Steve was talking about, and will go ahead and continue to hold that privilege. And this kind of gets into the common interest privilege that I was talking about. Courts also have the same sort of reservations about whether the common interest privilege can survive a reservation of rights for the same exact reasons. And then I've seen some courts also try to deal with it as a waiver issue, a waiver of the attorney-client privilege instead of common interest. So all of this is to say is that courts are struggling with how to characterize this relationship, and it should always kind of be in the back of your mind, you know, what we're sharing, just in case this gets into litigation. Here's an example of courts holding that no privilege applies when there's a reservation of rights. In Coster v. Junes, which is out of Michigan, it was a garnishment action, and the plaintiff from the underlying suit wanted communications with the insured's counsel, and the court ordered that they had to be produced because in Michigan, the insurer was not the client of the insured's counsel. Again, that relationship is reserved for the insured. And the court also went on to say that the insurer was also not acting as an agent or representative of the insured. So in that case, there was no privilege and those communications had to be disclosed.
I do have a question. With this interpretation for privilege, is it going to be case by case, or are these bright line rules?
They're not bright line rules, just because courts have themselves not really come to a bright line understanding of how to characterize these. And so they're not going to be bright line rules, and it's going to be jurisdiction specific and case by case specific. And there's also a possibility that there's going to be some in-camera review involved. So it's really not going to be a bright line rule to see how this plays out.
We had recently a very large, complicated coverage case, and we saw communications between the insured and the broker. And the court said that's privilege. And I've been successful in other cases getting it. Sometimes I've not, but it's, it's just, that's why we go back to what's important, how it's documented. If you're seeking legal advice, say, if seeking legal advice, it shows more likely than not, it's a privileged communication. If you're talking to the insured defense counsel and saying, I'm seeking advice to help me evaluate the claim, it would seem more likely than not, it would come under the common interest privilege. So it all depends on how you categorize it. One thing we didn't say is another red flag is bad faith. And I'm not sure, what your, policies are here at SAPO, but I'm a big, big believer is when you hear bad faith, either from plaintiff or the insured or defense counsel, at that point in time, you need to have a communication with management. Do we try to open up a separate file dealing with bad faith? Because if in fact you have coverage litigation, after, at some point, the coverage, you have to assume your coverage file is going to be produced, claim notes, etc. And if you have bad faith in there that is unique and different, which has a different legal analysis, because obviously bad faith is you put interests of SAPO before you're insured, and there's things in the claims file which you need to demonstrate you're trying to do everything you can for your insured. Just red flag, have that discussion with management. If there's bad faith coming in, what do I do with it? Do I keep these communications in my claims file, or do we have someone else responsible for the bad faith claims and step in and deal with those communications?
All right, we want to make sure that we leave just a few minutes. We're getting close to our time. We want to make sure that we leave some time for questions at the end, if there are any. But I guess just to kind of tie things up and recap a little bit, the issue of in terms of other discoverability considerations, the question is whether in discovery are claims files relevant. So under the federal rules, the federal rule of civil procedure on what is discoverable, it says that discovery is permissible of non-privileged matter relevant to any party's claim or defense and is proportional to the needs of the case. Now, there's a lot of different ways to interpret this, but that's the standard that's in the federal rules. And the scope of what's discoverable in a litigation is much broader than what ultimately might be admissible evidence in court. So at a trial. So the scope of discovery is always broader. While the claim file might be entirely discoverable, it might not all be admissible at the end of the day. But that's to say that the claim file generally is relevant and generally is discoverable. Some courts may not allow discovery in a breach of contract action that's determining coverage. For example, in Florida state courts, they've held that in first-party coverage disputes, an insurer's claim file may constitute work product and is protected from production. So in some courts, coverage must be established first in a breach of contract or declaratory judgment action before a bad faith claim can be brought. And the claim file may constitute work product and not be discoverable outside of a bad faith action. But generally speaking, the claim file is going to be relevant, is going to be discoverable. And these best practices that we've talked about with you today, we want to make sure you incorporate those, because in the event that your claim file does become the subject of discovery or litigation, we want to make sure it's as helpful to you and as helpful to us as possible. And what we can do kind of on the front end to make sure that we're not dealing with just difficulties on the back end in terms of just what's discoverable, what's going to be produced, depositions, and what we're presented with ultimately before a judge. So,
but remember, your communications with your insured is out there. Don't think it's part of my claims file and therefore it won't be used. Your communication is with your insured, with the defense counsel is questionable, but with the insured, your coverage letters, your communications clearly is evidence in the coverage action, and the insured has it. So it's not like we could then claim it's work product. It shouldn't be. It's going to, your letters, including your coverage letters, more likely than not, will be exhibits at a deposition attached to the complaint.
One last quirky little thing that came across in putting this together that I just wanted to share is that there are certain exceptions to the attorney-client privilege And one is the crime fraud exception. So that basically says that that material that's otherwise privileged must still be disclosed if the client intended to perpetrate a fraud and the communications was made in furtherance of the fraud. And some courts have gone to the extreme of saying that insurance bad faith is a matter of civil fraud for purposes of this exception. So courts have said that there can be communications there with your attorney, but if there's a determination, or if it's if there's bad faith at issue, it might the privilege might be subject to an exception to the crime fraud exception. You know, in Connecticut, yeah. So our view is that this is an obscenely broad view of these matters, and to suggest that bad faith might fall in line with something that would trigger the crime fraud exception is just a step too far. But the courts in Connecticut and other jurisdictions have more authority than I do. So
You recommend a separate file if it's not bad faith. So you have a claim file, and then you're sued, and it's not inclusive of bad faith. Do you still think it's good to have separate?
So Neil had a question, is when there's not bad faith involved, if it makes sense to have a separate file opened. Maybe kind of you're asking at that demarcation point where communications might be in anticipation of litigation. Our experience has been that we're generally presented with just the one singular claim file. And then, because nothing's going to be produced in litigation without it first coming to us, right? And we have a pretty good view of, we'll oftentimes take an aggressive position in terms of what is subject to a privilege and what is protected. And we'll oftentimes get a lot of pushback from the other side, but we won't back down to that, right? We're gonna stand our ground and try to make sure that all communications with counsel are subject to a privilege, the communications that you have with us. So we take it upon ourselves to make sure. So I don't know that a separate file is necessary. You want to keep a kind of limit. What's that?
I would do a separate file.
Steve has a different view.
I would strongly do, because, again,
Even with no bad faith?
well, again, it goes to, well, because part of, we're going beyond, but an antidote to bad faith is filing a DJ action, even under the reservation of rights. You can't have legitimate coverage positions and want to litigate coverage while you're still providing a defense or reimbursing defense costs. And to me, you want to have those. I would have the adjusters doing the claim. Adjuster, you claim as if there's coverage, and I would go to the coverage group, and Neil or someone else, you handle the coverage litigation, separate file, so that we have those communications protected. And you could go ahead and sue your insurer while you're still providing a defense for a coverage determination. The fact, as I said before, most states, bad faith laws want an earlier coverage determination. So my view is that you should do that, and it should be protected by a different handle. You don't want the same adjuster handling the coverage litigation that's handling that underlying claim by insured while you still maintain coverage.
And that's actually one of the, we raced through a bunch of slides there at the end, but one of the points I want to raise is that we oftentimes come across circumstances where things are in anticipation of litigation, but you're also continuing, like Steve was said, continuing to adjust the claim. And that's where that kind of bright line demarcation doesn't really apply, because when we're looking at what has to be produced and what's discoverable, it's really then on a one-on-one basis. I mean, because Neil, the matter that we're working on now, it's, there's coverage litigation, but there was still, and in many other litigations we have, there's coverage litigation that's in sight or in anticipation of or going on, but there's still matters that are being adjusted with the claim. There's still updates coming in from defense counsel, and it's then we have to be really careful about what is subject to the privilege and what is not.
We have a case in Florida where there is a bad faith claim that's being provided, and I said, quickly open a separate file. I do not want to hang out our analysis regarding bad faith exposure and the main coverage rider. And just got to help us keeping those things separate. We could still make those arguments that I wouldn't want to produce in coverage litigation. But again, where does it win? All we're trying to do is make sure you're aware, can identify the issues. as you're doing your day-to-day things to say, I want to make an informed decision. Talk to management, talk to counsel, but at least we're trying to get you to think of the red flags.
So at what point do you suggest that we open a separate file? Because I have a lot of claims where we have coverage counsel analyzing coverage for us, and it's just sort of mixed into the file.
Wait, really quick. So the question was, at what point should we consider opening up a separate file? Go ahead.
Give it put in the question so they can hear.
You're the one that insisted on a separate file. I mean,
No, I wouldn't, because you're looking at the issues. You're still formulating your position. You're conducting a reasonable investigation of the underlying facts to make a proper coverage determination. If in fact you're saying, hey, I anticipate they're aggressive, they got aggressive cap. I really think there's not coverage here, but I'm kind of the claims advocate for the brokers pushing. Sampo is going to make a business determination, but again, informed decision. I've seen many times when I know a firm coming in on behalf of the insured is very aggressive counsel for insurers. Red flag. I see the tone of the letters, red flags. Those cases I would be considered doing it. In your normal adjustment of the claim, I don't think you need to. But you'll see that you guys have enough experience. You sense when it becomes potentially hostile, when you think you're being pushed to take positions that you don't think are well vetted. And having, again, you're bringing counsel in to provide coverage or to monitor the claim or assist in the evaluation of the claim, to assist in evaluating the underlying exposure. So once you bring in counsel, I always try to make sure our communications are protected. And even though they may be in your claims file, I would not produce them without a court order. So I think I'm fine. That fate, is something different because I don't want to have in a coverage file bad faith exposure information, because that implies there's coverage and you're concerned about it. So that's part of it. Hopefully I answered your question.
But I think you just have to be careful, though, just not to use the red flags as a standard, right? Because the courts sure are not going to use red flags as a standard. The courts have their own standard of what's in anticipation of litigation. And like I said before, it's when the declination is issued. So you just have to be really careful about just because there's red flags doesn't mean, okay, I'm good now. We think litigation is coming at some point, but you're still operating under a reservation of rights. Your communications with counsel are not necessarily going to be protected. So it's one of those kind of blurred lines where there's not a clear demarcation. But this is one of the things I think you talk about with that we pick up the phone, talk about with counsel, and come to make a determination instead of an email. Hey, should we open up a new file at this point?
Yeah, and a lot of those communications, I always say, can be used effectively to demonstrate that Sampo's doing its job of looking, properly determining if there's coverage and looking after the interests of the insured. So even coming in, bringing coverage counsels to do that, I always tell clients, wow, every time you get sued, report that to your insurance company. But if you really think every lawsuit's covered, it's not going to be the case, because if every lawsuit's covered, you'll never be able to afford insurance because the premium's going to be so high. So we all play this, we just need to be careful when working through the process, understanding it, and just being cognizant of how we're maintaining our files in a way that's best protected. While we've gone over different privileges and things that apply, still safeguard is to always, who is it? Warren Buffett. I heard Warren Buffett speak, and he said, I want every employee of Berkshire to say, I have a New York Times reporter following me every day. And the New York Times reporter is going to put in the front page of the New York Times what I did and how I acted that day. It's something you want to make sure your mother and father did not be embarrassed about.
No.
It's that simple. Every day we all want to do the right thing.
So we're kind of at that time. And we're happy to stick around and answer any questions, have any discussions with everyone. If anybody has any questions about these issues on a going forward basis or on any issues, we're here. We're always happy to help and work with you guys. We work, as we mentioned before, we work with many of you frequently. And to those we haven't worked with, we really look forward to it. So thanks everyone for taking the time today.